When I became the chair of the section last summer, I didn't know anything about, and I heard about it, and I created a task force about it of some of the leading experts in the country to look at it. And at the same time, the president of the American Bar Association, Hillary Bass, became very interested in the subject as well. And the subject, part of what we're going to talk about today has to do with an increase in border searches at our borders, and actually international borders as well, of digital equipment. And you know, cell phones, laptops, anything digital, and the consequences of that. You know, it's one thing having your suitcase searched, it's another thing having your cell phone searched or your computer, and particularly for lawyers and for lawyers' clients, for reporters and other people that have confidential and privileged information. And I realized a month ago when the ABA, for some reason, had its mid-year meeting in Canada, so we all went to Vancouver at the beginning of February. And right before we went to Vancouver, we all got a notice from the president of the American Bar Association, and it was entitled Electronic Device Advisory for Mid-Year Meeting Attendees. And we were all advised, judges, lawyers, legal professionals, that we will be crossing the border in and out of Vancouver, and that we needed to be aware of what was going on and what could happen. And they proceeded to give us what amounted to be a brief, and we're going to talk about many of these issues today, about what our ethical obligations were as lawyers to protect our confidential and privileged information. They went through all the ethical rules. They went through a model, or a legal opinion that you're going to hear from Bruce Green today about, from the City of New York Bar, that has, talked about this. And then they gave us advice as to what to do when we were approaching border inspection, and what we would do if we were requested to give our passwords, and how to prepare for this. And this was this was sort of out of the blue for most of us, because I have a feeling that most of us here, and I'm one of the major offenders, has been traveling internationally and has not traveled with burner phones or clean computers, or had any thought about what could happen if one of our friendly customs agents or agents in other countries said, "I want to see your cell phone or your laptop." So we call this panel "Prying Eyes: Think Confidential and Privileged Client Information is Safe at the Border. Think Again." The ethical and legal challenges of increased border searches of digital devices. And then there's some other issues we're going to talk about today. We're going to talk about an incredible happening in Munich almost 2 years ago now, where the Jones Day's offices were searched by the Munich prosecutors, and you're going to hear about the contents of their entire internal investigation as it related to the Volkswagen diesel scandal was seized. And then we're also going to talk about some other cases in the UK. You heard a little bit in other panels about where, in essence, the work product of an internal investigation was compelled to be turned over. So what these pitfalls are, as we begin the process. So let me introduce this panel. I don't really need to introduce David Green. You already heard from David Green. Until April 20th of this year, he will continue to be the director of the Serious Fraud Office in the UK, and he's been there since 2012. We really appreciate, again, you coming over here and speaking with us and visiting with us. To my left is Joe Maurer. Joe is, yesterday he was the acting general counsel of the Department of Homeland Security. But yesterday, I guess the person nominated actually became the general counsel. So he's the principal deputy general counsel at DHS. He has been at DHS literally since almost the beginning of DHS. And what he's going to tell you, he's going to talk about a new policy or new guidelines that were issued by DHS, I think in January of this year, and he's going to, he's going to be prepared to discuss, how they view, how the government views, how DHS Border Protection views their ability to pretty much look at anything they want to at the border and why. To my far left is Jim Woolley. Jim is a partner at Jones Day in Cleveland, Ohio, former DOJ, former Manhattan DA, prosecutor, a distinguished white-collar defense lawyer who was one of the principal lawyers in the representing, doing the internal investigation in behalf of the Volkswagen Group. And he will give us a first-hand blow-by-blow of what happened in Munich a couple of years ago.
Can I say something, Sandy?
Yes.
So people get asked to be here because they're brilliant or they're doing a victory lap on a great result. I'm here because I got us rated. And until this very moment, it seemed like a good idea. Yeah. But
it is a good idea.
Right now, I'm just not so sure. But
it's a very good idea. And then to my far right over here is my friend Bruce Green. We were assistant U.S. attorneys in the Southern District of New York a long, long time ago. Bruce is a longtime professor at Fordham Law School and one of the leading ethicists in the country, and is the principal drafter of the New York City Bar legal opinion on this very issue that was issued last summer, I think, around last summer. Then on my immediate right here is Adam Schwartz. There's lots of Adam Schwartz out here, including somebody that used to work for me for a long time. But this Adam Schwartz is with the Electronic Frontier Foundation, EFF, which is, we've had a number of panelists from EFF over the years. It's the leading, I would say, or one of the leading nonprofit organizations defending civil liberties in the digital world, founded in 1990, and they just do incredible work. And Jim will speak to their efforts in this area to give us advice and to protect our civil liberties as it relates to this emerging area. And then to Adam's right is Carrie DeSalle, and Carrie is with the Knight Institute, First Amendment Institute at Columbia University that essentially does what the Electronic Frontier Foundation does, but focusing on First Amendment rights that are also challenged by these searches. So it's a wonderful panel, and hopefully we'll leave some time and there will be a microphone around because I imagine there will be a number of questions that people might have to try to avoid doing what I am about to do next week when I go to Germany, and I'm not sure that I'm going to be following the advice that we're going to be giving you today yet. In any event, Joe, why don't we start with DHS by you outlining for the audience what the state of the law is from your perspective. We're going to hear from the Electronic Frontier Foundation and the Knight First Amendment group as to how they view this. But tell us how you view this and from the perspective of DHS, Customs, Border Patrol, and the ICE components.
Sure,
all right?
Sure. So just to start with, the first question is, why do we do what we do at the border? So under a statutory mandate from Congress, our Customs and Borders officials are charged with doing a number of things, including interdicting terrorists, drug smugglers, human traffickers, protecting against dangerous goods and things from coming in, enforcing customs and trade laws, and things like that. So what does that mean kind of practically? What are examples of that? Well, that means that they detect evidence related to terrorism and deciding who gets into our country. They look at human and bulk cash smuggling that happens at the border. They enforce export control violations. And they try to determine people's intentions about what they're going to do when they come into our country. They detect firearms, chemical weapons coming across the border, as well as making sure that classified information doesn't leave our border. So that's kind of the background of why we do what we do and what our objectives are. But there's also a very long line of Supreme Court case law that goes back and describes kind of the unique nature of what happens at the border, which is very different than law enforcement activities in the interior of the country. The Supreme Court has long said that the United States as a sovereign has the inherent authority and a paramount interest in protecting the territorial integrity of the United States borders, and that the United States' interests in protecting that is at a zenith at the border. So what does that mean? So the Supreme Court has repeatedly said that the fact that a search happens at the border is reasonable by virtue of the fact that it's at the border, because expectations are different and because of the unique sovereign interest the United States has there. So the Supreme Court has also said that repeatedly that routine searches at the border don't require reasonable suspicion, probable cause, or warrants.
In other words, you can search pretty much anybody you want to.
Correct. Anybody who comes in, whether
But
they're...
for no good, you don't have to articulate a good reason.
Correct. So whether they're U.S. citizens, aliens coming across the border, in general, they can go through your luggage. They can ask you a lot of questions as they're coming into the United States. Right. So that kind of constitutional background is also supplemented by affirmative authorities that Congress has given in statute. So there's a long list of those authorities in Title VIII and Title XIX, the most important of which date back to an act of August 4th in 1790, where that Congress basically gave authority to operate at the border. So that's kind of a backdrop. Now, we talked about routine searches. I think people later on will talk about more non-routine searches, where some courts of appeals, most notably the Cotterman Court in the Ninth Circuit, has added additional requirements. But kind of a key thing I think to keep in mind here too is, we're talking about constitutional principles, but Congress also has and can act to either authorize or restrict the Department of Homeland Security's activities at the border. So that's kind of a broad background of where we kind of start from as we engage in our activities.
So just give us a sense, because the issue here is that yes, and we're going to hear from the Electronic Frontier Foundation and Knight, but yes, we know about this, but as it relates to digital, things may be somewhat different. So give us a sense of how many digital searches have been done and the increase between the last fiscal year and the year before.
Sure. So in the most recent fiscal year, we have data for fiscal year 17. There were 30,200 searches on electronic devices done at the border, and that's in the context of having 397 million travelers enter the United States for that year. So putting that in context, it's less than 1/100th of 1% of travelers had their electronic devices searched at the border. In fiscal year 2016, the number was 18,400 searches of electronic devices, and a little bit smaller number of travelers, 390 million travelers coming into the United States. So again, significantly less than 1/100th of a percent, 1/100th of 1% of travelers having their electronic devices searched.
And do you keep a record of who gets searched, by race, color, religion, nationality, lawyers, non-lawyers, journalists, others?
There definitely is documentation kept about when searches are conducted. I don't think we keep information about what the race was of the person searched, things like that, but identifying the individual and no information about the search that occurred, that is documented.
So tell us what happened. I mean, given the fact that you have all this case law and authority, and you can pretty much search anything you want to according to your view of the law, why then on January 4th, 2018, was did DHS or through the Customs Border Patrol issue this new directive on electronic devices, and what does it mean for all of us?
So part of the reason was certainly because of the shift in case law. So the Ninth Circuit has a different rule that it articulated in Cotterman than other courts of appeals, which had ruled differently. And so that's one element. But also, it was the considered judgment of law enforcement officials and the leadership at CBP about what they need to do their job well. And so I can kind of walk through if this is the right time to.
Yeah, why don't you walk through it and then we'll.
Yeah, so one of the major kind of shifts in this new protocol is that it has different standards based on the different types of searches. So it has basically kind of two types of searches it outlines, a basic search and an advanced search. And so when you have an advanced search, that's basically essentially anytime you hook up the device to another device for purposes of reviewing and analyzing, downloading the material. That's what we term an advanced search. A basic search is something less than that, something where someone just kind of thumbs through the device to look at what's easily accessible. So the different standards we have, reasonable suspicion is not needed for the basic type of search, but for the advanced search, it generally does require reasonable suspicion and approval by supervisors.
Right. And what about attorney-client information? Does this new directive speak toward that?
Yeah, so it does speak about attorney-client information. So we basically have a protocol in there that says that if someone alerts one of our officials that there's attorney-client privileged information on the device, the person will kind of ask the traveler details about that. Can you tell me which files that is? Can you tell me what the names might be associated with the privilege for purposes of being able to segregate that information? Before conducting the search, the border officials are instructed to call the chief counsel's office that works for Customs and Border Protection to get information, and there's a filter team that's basically set up in order to handle the segregated information.
A filter team at the border or in your office or what?
It's a combination of attorneys as well as operational folks.
And does the lawyer get to speak to you or some other lawyer when this happens?
So it's a little bit hard to generalize because it's so rare that we've done searches of attorneys' materials. Even internally asking folks, I couldn't find anybody who thought there was more than 10 people out of the 390 million that came across where this applied to. So generally, travelers don't have kind of direct access to our legal office, but I think we are very committed to kind of handling these things case by case as they come up. And making sure that we do the right thing.
And then a couple of more things, and then we'll hear, why this really is a problem for us. What is the obligation of the traveler with regard to when you ask the question? This is in your policy. When you ask the question to the traveler or to a lawyer, I need your passcode. What's the obligation? What's your position that the obligation of the lawyer or the traveler is?
So when you travel into the United States across our border, as a traveler, you're obligated to present your person and effects to be searched. And so, our view is if we can't get into your device because it's password protected, they'll ask the traveler to open it. If the traveler refuses to open it, that may have a number of different implications depending on the nature of the person. If it's a U.S. citizen, it's not going to keep the U.S. citizen from being admitted into the country. But it may keep the person from being able to take the phone with them because there's an obligation to be able to search any effects that come across the border.
So you might, in that circumstance, take the phone.
Correct. Right.
And you might take the phone anyway, right? I mean, whether I have a passcode or not, you can take the phone if you want to.
Well, I think we generally don't seize a phone without probable cause if there's just to retain it.
What do you call it, a seizure at the border, or do you just sort of detain it for a week or two?
We'll detain it for purposes of searching it. So, in customs law, there's a difference between kind of detaining something to search it.
I wasn't trying to be funny. I mean, it's really,
right.
It's your distinction between the detention of a device for 2 weeks and the seizure of the device, right?
Right, so we'll detain the device in order to be able to search it. Once we've searched it and it's, we're done with it, we'll return it.
Okay, Adam, why don't you tell us how you view the state of the Fourth Amendment law regarding searches of digital equipment like cell phones and computers at the border, and in particular, sort of explain what is happening out there as it relates to Fourth Amendment law and why, digital equipment is, in your view, so different than searching a suitcase or a briefcase.
Sure. There's a century of cases from the Supreme Court and other courts dealing with the application of the Fourth Amendment at the border. And as Joe has said, they give a lot more power to border agents and a lot less privacy to the public at the border compared to the interactions of police officers and civilians in the interior of the country. The cases are largely oriented towards protecting the country from the entry of contraband, touchable, largish physical objects. So in the case of Montoya de Hernandez, the concern was somebody smuggling drugs in their stomach into the country. And in Flores Montano, the concern was somebody smuggling drugs in the gas tank of their car. And in Ramsey, the concern was someone smuggling an object inside a letter that was crossing into the United States at the border. We think that these kinds of cases simply are completely different from the kinds of issues we're talking about now with a cell phone. I don't know how other people live their lives, but this device is never further than a few feet from my body. And basically everything I do or think or say is passing through this device. Where I've been, my text with my wife about who's going to pick up the kids, I went to synagogue on this Saturday but not on that Saturday, my medical records, my banking records, what newspapers I'm reading, my fitness activity. If you want to know anything about me, it's in here. And this is just completely unlike, a balloon of heroin that might be in my stomach, or, a kilo of heroin that might be in my gas tank. It's a window into the soul. And it's a window into the soul of everybody who's crossing the international border. There has been, I would say, a revolution in how the U.S. Supreme Court thinks about this issue, which is shown by the Riley case decided in 2014, which said when somebody has been arrested by a police officer on probable cause, this is somebody who is, there's a factual predicate to believe they committed a crime. They've been caught with drugs. Unlike the millions and millions of people who are crossing the border for whom there's no reason to think they're guilty. Even this arrested, suspected person with a flip phone, not a smartphone, has a Fourth Amendment right to have their phone not searched. The police still have to go get a warrant. And the Supreme Court speaks eloquently in Riley about the massive amount of information that's in our phones and the sensitivity of that information, and therefore why the warrant ought to be the standard to get into the phone. And so, all these cases about the border that Joe and others will talk about, they're simply pre-Riley. And we think that in the wake of Riley, there needs to be a radical rethinking. And we expect courts to ultimately impose a warrant requirement as the condition for border agents to search a phone. We have a lawsuit, EFF and the ACLU, called Al-Assad versus Nielsen, filed in Boston, which seeks to do just that. And there is legislation in Congress that likewise would do just that, a warrant to get into the devices.
So before we get to the lawsuit, because I do want to talk about it, and in the lawsuit there are 11 clients that you describe, and none of which are drug dealers or smugglers. They're journalists and business people and students. I do want to, it's not just the Riley case, but there is pending the Carpenter case right now in the Supreme Court, and I guess they're going to rule before the session ends. The Riley case had to do with the Fourth Amendment exception search incident to arrest, which had been in place for decades. And as it relates to digital equipment, they made it clear that the warrant was necessary. And the Carpenter case, that I think y'all were involved in as well in some way, has to do with cell site locator information. And it's the third-party doctrine exception to the Fourth Amendment, right? And this, depending on what they do, if they go the same way as Riley, why not the border exception next?
Right. I think this question of how the Fourth Amendment protects devices at the border is part of a larger tapestry of cases where the courts are grappling with other technology questions. And so the year before Riley and Jones, the issue was police putting GPS devices on a suspect's cars and watching where they go for a month. And the Supreme Court in Jones unanimously said this was a Fourth Amendment event. There were different majorities of the court, both involving Justice Sotomayor, that said this was a Fourth Amendment event, both because it was a trespass, but also because it intruded on reasonable expectations of privacy when you talk about pervasive digital surveillance of what somebody is doing. EFF is an amici in the Carpenter case before the Supreme Court now, involving cell site location information. We thought that the oral argument went well, and we do hope that the Supreme Court will likewise protect, under the Fourth Amendment, police access to the cell site location information. That will be instructive, no doubt, in how the courts resolve the Al-Assad case.
So, Carrie, why don't you describe to us, A, what the First Amendment issues are? We've heard what the Fourth Amendment issues are, but what are the First Amendment issues? And then secondly, both you and Adam, can you tell us what your organizations are doing and recommending to people that follow your organizations, what they should do when they're traveling with digital equipment? And then we'll go to Bruce and talk about what the ethics issues are.
Sure. Well, so in the case that both Joe and Adam referenced that kind of first articulated the border search exception to the Fourth Amendment's warrant requirement, United States v. Ramsey, the court there actually was very explicit in carving out a separate potential First Amendment concern with respect to the search of items crossing international borders. In that case, it was physical mail. Border Patrol there searched the mail based on a suspicion that it contained heroin, so a similar concern that animates the searches that we were discussing before. But the regulations pursuant to which they conducted that search explicitly prohibited the actual reading of any mail that crossed the border. So even the kind of origin case to the border search exception, we think makes clear that there are separate First Amendment concerns when it comes to these kinds of searches. And the First Amendment concerns at issue with the search of electronic devices really are the core interests protected by the First Amendment. So it's the freedom to speak and the freedom to speak anonymously, which the Supreme Court has recognized multiple times, very clearly in McIntyre v. Ohio. Secondly, the freedom to privately associate with expressive organizations, which the Supreme Court recognized in NAACP v. Alabama, in addition to other cases. The right to receive information and ideas without government intrusion. There have been numerous cases where government officials have tried to force either booksellers or individuals themselves to disclose the lists of customers or the books that they themselves have been reading. And the Supreme Court has said that that's effectively an intrusion into the freedom of thought and inquiry and a barrier to this protected right to receive information and ideas. And then finally, freedom of the press. The Supreme Court in Brandsburg v. Hayes, although it didn't rule in the reporter's favor, still recognized something of a qualified reporter's privilege. And subsequently, courts have recognized a reporter's privilege in many cases, and many states have actually enacted shield laws, as well as the District of Columbia. And these protect the news gathering process. They protect journalists from being forced to disclose confidential source information and other elements of their work as news gatherers. So cell phones contain all of this information. They contain search histories of our, when we're looking up articles on different topics, or the newspapers that we read, as Adam mentioned. They contain memberships in political organizations or religious organizations. Many people identify with those organizations on social media. And of course, they contain extensive communications with loved ones and colleagues. And for journalists, they certainly contain a wealth of what may otherwise be protected information that they compile in furtherance of their press responsibilities. So we think that all of these First Amendment interests should merit strong and independent consideration when the courts are looking at the constitutionality of these searches.
So is this, listening to Joe, I have a better chance to win the lottery than to get searched at the border have my digital equipment. Is this something we really should be concerned about, Adam and or Carrie? And are people, other than drug dealers getting searched?
Well, many people are getting searched and not accused of any wrongdoing. What the government has not done is produce statistics about hit rates. With other law enforcement practices, like searching a car after you stop it, or searching a pedestrian on a sidewalk, hit rates are available. So we have no idea what portion of people who are subjected to these device searches are caught with contraband, because the government hasn't told us. I would say that it is standard that when a law enforcement practice is an inappropriate violation of the Constitution, it's only happening to a small number of people. So New York City, stop and frisks of minorities in violation of the 4th and 14th Amendments, it was not happening to every person in New York. It was happening to a small portion of New Yorkers. Same thing with traffic stop racial profiling programs. So the fact that this is happening, 1 in 100,000 times to travelers, we think does not give any cause for comfort and is no barrier to prosecuting a lawsuit.
Can you give a couple of examples of the plaintiffs in your case that's pending in Boston?
Sure. One of our plaintiffs is a retired Army captain who is now a university professor who teaches about international security and terrorism, who, when crossing, they asked her to unlock her device, and she felt, based on the demeanor and the manner of questioning, that she had no choice, so she unlocked her device. And agents took it out of her sight for an hour or so, and she found that to be a very humiliating and invasive experience. We also represent businessmen, a computer programmer, a cab driver, 3 journalists, just an artist, a movie maker, just ordinary people who, one by one, a NASA scientist, for no apparent reason had the devices taken from them, never were accused by the government of any wrongdoing, and went through this intrusion, which again is a stranger looking through this window into your soul in a very invasive, humiliating manner. And so they've come together to file this lawsuit.
And is there any demographics? I'll ask you. Do you have demographics on, is it the people that of the 30,000, Muslims, journalists? I mean, is there any statistics as to who these people are?
Yeah, I don't think we tabulate statistics about kind of people's religion or ethnicity and who are searched. So I don't think that we have that kind of in a...
And how about y'all?
As far as I know, there isn't. I just want to say again, modern law enforcement practice, when you're talking about police stopping cars, police stopping civilians on sidewalks, is to document the identity and demographics of the person searched and whether or not there was a hit, so that after the fact you have a set of data that management can use to see what is going on. And so whether or not there is racial profiling because there's documentation. But with the equally invasive and problematic practice of border device searches, we're flying blind because this government agency has chosen not to document this kind of thing. I can say that if you look at media reports and you look at the intake coming to nonprofit organizations like the EFF, but also the ACLU and many others, it does seem as though more Muslim and Arab Americans are being targeted for these border device searches than other Americans. And so 6 of the 11 plaintiffs in our lawsuit are Muslims and Arabs. So we need these hit rates. We need this documentation of who's being searched. And I would add that it's great that we know that there are 30,000 searches last year by CBP. We don't know how many searches there are by ICE. Frequently, CBP will hand the device off to ICE, who actually will do the search. Sometimes at the airport, CBP will call ICE and say, what should I do with this device? And ICE will say, seize it and give it to us. So ICE is very much in the mix, but we don't know how many ICE searches there are. So we view the reporting by the government about what's going on to be woefully inadequate to the public understanding how this incredibly invasive practice is being implemented.
So Joe, ICE and CBP are all part of DHS, of which you're was the acting general counsel of, right? It's the same agency.
Yep.
So CBP put out new guidelines in January, but ICE didn't. So does ICE operate under a different regimen than CDP?
So ICE operates under a protocol that was issued back in 2009 along with the CBP one. It's currently being reviewed and reassessed. But let me just say a little bit about that. So these searches are actually documented, and you can tell the individual and by the nature of what they do, what country they're from, whether they're U.S. citizens, things like that. So not only is there documentation every time there's an electronic search, but there are multiple layers of audits and reviews. So one division within the Office of Professional Responsibility does...
That's in your...
within our department,
within
right,
your department.
does auditing of the searches. The Inspector General of the Department of Homeland Security does an annual review to make sure it's done in compliance with federal statutes and rules. And then, of course, we have a lot of oversight by our congressional committees. So there are repeated, and another layer is the privacy officer for the department does an annual review. So there are at least 3 or 4 layers of auditing, documentation, and review that are done. I'll also say that our public transparency with issuing these protocols, I don't know of any other country that does that. We are we've done a search to the extent we can, but a good academic study would be to see what other countries have done. We have been incredibly transparent both in what we do, how we do it, and having our activities audited in a way that I don't think any other country has.
Joe, do you know how the other countries do it? I mean, places we all travel to, you know?
So the only, I think, publicly acknowledged one that we've seen is that the Canadian version of the Border Patrol basically takes the same position. They don't need to have a warrant to conduct these types of searches. But I don't know of any other country that publicly states what their protocols are for this.
Well, fortunately, we have somebody from another country. So can you tell us, are the British doing this?
What I can tell you is this, that the Serious Fraud Office has Section 2 powers, which I mentioned yesterday. They are powers to compel the production of documents or digital files or anything really. And there are also powers to compel explanations or accounts from witnesses. The only limit to it in the latter respect is that what a witness says cannot be used against them unless they lie to us. Now, what we've done is to increase the use of a version of our Section 2 powers, which are called here and now. In other words, if you are given a Section 2 notice by an SFO officer, and you are asked to produce something here and now, you have to do it on pain of imprisonment. And we've used this at the border, especially in relation to electronic devices for people, say at airports and so forth, and found it extremely useful. It is not a power of search. That's an important distinction because a search warrant would be required for a search. It's a power to compel production of relevant material. Now, in amongst that material may well be LPP material.
Which is litigation protected information.
And obviously we cannot see that, so that's obviously specifically excluded. So what we do in those situations is by agreement to have the device examined by independent counsel to sift out the LPP material. Indeed, we've had a recent judicial review of this where a lawyer's phone was seized at the airport on a here and now, and we were taken before the administrative court in London. The court actually gave, and the point was, they were saying it was an unreasonable exercise of our Section 2 powers because being a lawyer's phone, it was bound to contain LPP material. Now, the court didn't actually make a ruling in the case, but what they said was that we were to go away with the other side and agree a sensible mechanism by which independent counsel could look at the contents of the phone and remove material that was subject to LPP. In any event, within the office, when phones and so forth are seized, they are dealt with by a specific section of the office and not by the case, and the case team are not privy to any LPP material. I think that's about as far as I can take it.
So when these searches of your clients, because people come to y'all's organizations, take place at the border? Are the searches of the phones or the computers done in front of the person, or is it taken away and done?
We've seen the search in front of the traveler. We've seen the search for an hour outside of the traveler, but then they get it back and they go home. And we've seen devices confiscated and taken away for weeks or as long as 10 months, and then they get them back. I do just want to say, in regards to the last exchange, one way that I think the United States may be doing this better than some other countries is whether or not you get arrested if you come home to your country and don't unlock your phone. As Joe said, if you're a U.S. citizen and you're coming home and you don't unlock your device, well, maybe they take it, but you proceed on your way without an arrest. We have heard reports from England and from Canada of people coming home to their countries and getting arrested for not unlocking their phones. So that is a point where, as U.S. citizens, we can be pleased with our government.
So one other thing, Joe, I wanted to ask you, and then we'll get to Bruce. One of the big concerns I believe that y'all would have is the ability on a device to go into the cloud, to go into the internet, and then you unlock, more stuff than you can believe, right? I mean, that's a big concern, correct?
It certainly would be, although the new policy
Well,
isn't.
that's what I'm going to get to. So, but y'all have addressed that, at least, right? So in this new policy, you say, we're not going into the cloud.
That's right.
Now, but is there some case that says you can't go into the cloud, or y'all just decided to do this because you think it's right?
I think we decided to do it based on kind of our judgment, law enforcement interests, and also in recognition of the legal landscape that is here and is coming. The Cotterman opinion, the judges there talked about the issue of the cloud. So we understand that
Judge Roberts and Riley was concerned about that?
Yeah.
Justice Roberts.
Right. So we understand that presents a different aspect. And so basically the instruction to our officials at the border is that when they review a device, they're supposed to disconnect it from the network, either by asking the traveler to disconnect it, him or herself, or having the official
And how do I do that? How do I
if
disconnect
you just
it?
put it in airplane mode, you can do that.
But you could take it out of airplane mode if you wanted to, right?
Right. Our officials can violate the rules, yes. But ours
So when
don't.
it's taken out of my presence, I just have to be
So our default
comfortable.
is that the search usually should be done in general in the presence of the traveler. There may be operational or law enforcement reasons why that doesn't happen, but kind of the default under the protocol is that it'll be done in the presence of the traveler.
Bruce. So this is an ethics panel, and
So I
everybody needs their ethics credit, okay? And I gave this big, statement about how there's this, ethical issue. So why don't you describe, first of all, what kind of ethics issues are there? Is this real? Is this something we should be concerned about? Am I violating, some professional responsibility rule because I'm going to Germany next week and I might take my cell phone with me and not a burner phone? I mean, tell us, and what has the city of New York done
Okay.
about this?
So this was all the warm-up act for this ethics stuff.
Yeah,
right?
exactly.
Yeah.
Ethics stuff is a good way of putting it.
There's, of course, until the ABA started getting concerned about this, and then the city bar wrote its opinion, we all could just ignore this, and maybe there wasn't an ethics issue, but because of the attention, maybe, so in a paradoxic sort of way, it's become an ethics issue. But there's a couple relevant ethics rules. One, obviously, lawyers can't knowingly disclose or misuse their clients' confidential information. Secondly, lawyers have to be competent, and that's always been understood to include a general obligation to take reasonable measures to protect clients' confidential information. But then, a number of years ago, the ABA adopted a provision, Rule 1.6c of the ABA Model Rules of Professional Conduct, and different states, including New York, adopted provisions to basically codify what was always the case, which is that lawyers have to take reasonable measures to protect against the unauthorized disclosure of clients' confidences. So that's sort of the principle that you're not supposed to talk about your clients' cases in the elevator for example.
Or outside a restaurant,
Right,
D.C.
right, or to leave your attorney-client privilege documents strewn around where people could read them, et cetera. So the principle isn't that complicated, but the question then became, how, if at all, that applies in the context of lawyers taking their cell phones and laptops, et cetera, across the border and back. And so the City Bar, as you pointed out, in the summer of 2017, issued an opinion on how the rule applies in this context. And it was the first, and probably so far the only, Bar Association Ethics Committee to do that. And there are lots of bar associations, including the ABA, that have committees that issue opinions interpreting the rules of professional conduct as they apply in different contexts. But the City Bar, I think, since I chair the committee, does a pretty good job of it. Although one of my friends in a prior panel dissed the opinion, but he's not here now. But I do want to point out a couple of the limitations of the opinion, because first of all, the standard itself, you have to take reasonable steps to protect confidences, is a pretty vague standard. So you can't really issue a sort of categorical how-to, step-by-step, an opinion interpreting a reasonableness test. It's like, in attorney malpractice. And it's, even under the ABA model rule, the comments are sort of multi-factor. And second of all, of course, everything is evolving. So the policy has changed since the summer of 2017, and it could continue to evolve. The technology is always evolving. And so it didn't make sense to us to say something, too clear, maybe I should say, or categorical, because, it would be obsolete in a while. And third of all, the rule itself is just a disciplinary floor. It's an expression of the competence standard, but how many of you in your professional practices aim to be minimally competent, right? So, we give a little bit of guidance about where the rock bottom minimum is, but none of you should be aiming for that. And in the policies you adopt in your own law firms, you should be aiming higher, not for the floor. And of course, the opinion itself is not authoritative. It's not an expression by a court. But we thought it would be useful not only in this context, but also it provides a sort of roadmap to thinking more generally about what it means to take steps to reasonably protect clients' confidential information. And it comes up, obviously, in so many contexts. If you're using the hotel computer, what do you have to think about if your client is communicating with you using their employer's computers? What do you have to think about, not only when you're coming back to the US border, but when you're going to China or Russia or places where you might be hacked, or where you might be searched, or your stuff might be stolen. And so this is just one context among many. But back to returning to JFK with your cell phone. So a couple points about the rule itself. So first of all, it's about the protection of confidential information. And that's broader than attorney-client privilege information. And so sometimes my students forget this, which is why I get to grade them on a curve. And sometimes even lawyers forget this. So confidential information is anything relating to the lawyer-client relationship that the client hasn't authorized you to disclose. So your email communications with the client may or may not be privileged. They probably are. But at minimum, they're going to be confidential. Documents you have about your cases, interview notes with people other than your client may not be privileged unless they're interview notes with the employees of a corporate client. But they're still going to be confidential. And so you may have a lot of stuff on your laptop and your cell phone that's confidential. And presumptively, when third parties who are not authorized look at it, that's a bad thing no matter what they do with it. So it may be that the Department of Homeland Security isn't taking it and using it in a criminal case. It could be that the agents who review your client's confidential information aren't going to remember it by the time they get home. But the disclosure of confidences to third parties where not authorized is a harm to clients. It can chill future clients' willingness to confide in you, and so that's a bad thing. What does unauthorized mean? When we discussed it, I think everything in the opinion actually would strike all of you as obvious and correct, but there was one minority viewpoint that we beat it out of a committee member who thought unauthorized means not authorized by law, and since the Department of Homeland presumably is acting pursuant to law, none of this is unauthorized and we don't have to care about it. But what the opinion said is, no, this is about unauthorized by the client. The client hasn't authorized Department of Homeland's folks to look at it, and so that is a problem. And then the real issue became, what is reasonable? What are reasonable efforts? And so a number of the things to think about. Well, one is the risk, and so you hear from Joe that only 1/100th of 1% of travelers are going to be searched. It doesn't sound like much of a risk. And if you read, and you can correct me if I'm wrong, some of the additional written material, one might think that U.S. lawyers are at even lower risk than that because they're not really random searches, and sometimes they're precipitated by tips from the FBI or other reasons to think that somebody might be carrying pornography or terrorist stuff or other things that you're concerned about. And so, the likelihood of a search of a U.S. lawyer is pretty low, and so one might take the view that the risk is so negligible that you don't have to worry about it. But that's not the view that the opinion took. We think any risk is something you have to think about. Second of all, you have to think about the sensitivity of the information. And so the folks in this room who might go abroad to do interviews in white-collar cases, I think, have to be more concerned about this than I do, carrying my phone with my emails with my students. And so I assume you guys are carrying pretty sensitive information if you come back with interview notes and documents that people might give you, and that raises the need to do something. What are the available options for you? And this is, again, the technology is always changing, and you guys are probably more qualified to talk about it than I am because I had to rely on the people under age 40 on the committee to talk about this. But you can wipe your devices and store things remotely and not carry any confidential information. And then what's the need for it? So unless there's a real need, you don't really have to carry the confidential information of all of your clients unless you have a need to do that. So these are all things you have to balance. There was a suggestion in the opinion that unless there's a good reason, you should not be carrying confidential stuff across the border. So that was the first point in the opinion, which is what do you bring with you? The second issue in the opinion was what do you get when you get to the border and somebody from ICE or Customs asks to search your phone. And there's you all know opinions that say that before, for example, you comply with a subpoena for privileged documents, you have to take available measures to avoid doing that. And so you may not have to go into contempt, but you may have to assert the privilege and litigate it. And so the question for the committee was, what is the equivalent at the border? Do you have to let them cart you away in handcuffs? Do you have to turn around and go back to Canada or wherever you were? And what the committee said is you have to know the policy going in. And so now all of you are qualified to do this, and you ought to carry lawyer identification. And taking advantage of the policy, you should identify yourself as a lawyer, and you should identify files that are privileged or confidential, and you should ask to take it up with a supervisor because that's all consistent with the policy, and you should make whatever arguments you can make why this stuff should not be taken or searched. And only after you lose out on all that do you surrender the device. And you may have to surrender the password. But if there are opportunities, there may be, as time goes on, opportunities to litigate this stuff, but I don't think at the moment there's a feasible opportunity when the ICE agents take this stuff. And then lastly, what do you do if your device is searched and somebody's reviewing client confidential information and the opinion says you have to let the affected clients know because you have a duty to tell them things that they're entitled to know, and this is one of those things. One question is, how do you know whose confidential stuff they've looked at? Well, of course, if you've minimized what you're taking, that makes it easier. I don't know what the customs folks will say when you ask them, but there's also, I think, technological ways when you get the phone back to figure out what was reviewed, and you may have to do that. So that's sort of the opinion in a nutshell. Is it the be-all and end-all? I don't think so, but maybe it provides some guidance.
So bottom line, do I need to travel with what we call a burner phone, a clean phone?
Well, what would be on your phone if you don't?
Pretty
Without
much my
violating
entire life. All my, emails with clients and, documents and things like that.
But why are you, first of all, your entire life, the rules don't care about, they only care about the client
Well, I
stuff.
care about my
So
entire life.
So your soul, we don't care. But if it's the client's soul, yeah. So why are you taking all this stuff on your phone?
Because it's easy.
Okay, so there's a little bit of risk here, and of course nobody's going to ever know until it comes up. But I do think there's not only disciplinary risk, but there's reputational risk and client relation risk, and even civil liability risk. And so there's an issue of your risk tolerance. But I think it's unreasonable for you to take sensitive, confidential information across the border if you don't need to. And by the way, it's not just our own customs agents; it's other people's customs agents and other people who might access your phone or steal your phone or hack your phone.
So we're not quite to Jones Day yet, but Jim, I'm going to ask you a question that I actually didn't talk to you about. But does Jones Day have any kind of policy on this? I mean, Jones Day's lawyers are going all over the world.
Yeah, not that I know of. And maybe I
Might
should.
they
Maybe we do.
soon
but
have a policy on this, do you think? Is this something that concerns you as you're listening
It does.
to
And
this,
as I'm hearing
discussion?
this, I'm actually more concerned on the real life experience we had. In the case you're involved with is like in Germany. I mean, if you're going to go, Sandy, and work on this, then come back.
Right.
Given that they've already shown a willingness to raid law offices there directly related to the case, it seems a little less abstract and potentially more of a real. So that's I was kind of probing if people sort of know how our folks do it in Germany.
So, Joe, if I get selected because for some reason, I guess it doesn't even have to be a reason, but I get selected, and it turns out that I followed this advice and I got a burner phone. Is that like telling an FBI agent that, I don't want to talk to him, I want to get a lawyer? I mean, is that, is that a red flag?
I don't think it should be in light of what our own protocol is, discussions like we're having today, the New York piece. I don't think that should be or that it will be. But I think that the New York piece raises an important point, which is when you are developing your own reasonable expectations of privacy, you have to really question, do you have that when you take your cell phone across the border? Because you may know what our protocols are. You may be able to tell us that you're a lawyer, talk to our supervisor, but you don't know what's happening in the country you're going to. And so, it's really, I'm not sure that you actually have a reasonable expectation of privacy if you don't know that when you're going across the border into another jurisdiction.
Well, I guess we're trying to figure out this one first. So it's from the government's perspective, what are the best things that a lawyer can do, short of not carrying a digital device, which is sort of not practical in some sense, to minimize the risk that confidential privileged information will be reviewed at the border?
I think a couple things come to mind. One is, I think like others have said, identify yourself as a lawyer. Do a little work before you get to the border where you segregate files into, if you need to take something, it's into a file so it's easily identifiable. You can help us so that we can easily segregate that stuff. I think that's practically the most useful thing you can do. But another answer might be, disclosure to your clients. Telling your clients, here are the chances of people getting searched as they cross the border. Here's the type of information we have, and see if they'll consent to you walking across the border with your phone. There may be some clients that are willing to do that.
Bruce, should we be telling our clients, warning our clients about this as well? I mean, not just our travel, but their travel?
Well, you know, it depends what you're carrying and how sensitive it is and why you're doing it. But, you know, I do think that if you're going abroad to meet with a client and then planning to bring back really sensitive stuff, it's worth a conversation, because there may be other ways in which to bring that stuff or transport that stuff that have lower risk. And so it may be more expensive, but it's a client decision whether to take the risk or to accept the expense of transporting things in different ways.
So not just lawyers, but what do you advise? What does your organization, Adam, and I think Carrie's as well, but at least Adam's, has put out guidelines for your clientele, basically, right? I mean,
That's right, and I think this dovetails really well with Bruce's suggestions of what is reasonable. If you go to our website, EFF, and just put in border pocket guide, there's a one-page sheet that folds up into this cute little book here, and we suggest several things for everyone. Number one, we've been talking about, which is carrying less data. So maybe get a burner phone and a Chromebook instead of your usual devices.
now, what exactly is a Chromebook for those of us over 35?
A Chromebook is an inexpensive product that basically has no memory on itself as a laptop, and everything's in the cloud. And so I say Chromebook simply because it's one of the less expensive devices that will put less information on your device when you're in Germany, talking to your clients. It's out in the cloud. Number two, have good passwords. Lots of us are using a password that's just password or 123. The way to do it is called diceware, which is if you just Google EFF diceware and roll 3 dice, it will assign you 3 short memorable words like staple, horse, mouth. And the wonder of this is that it's going to be a long password that the government can't brute force with a computer. It is memorable to you, unlike XYZ1 hyphen, and no one's going to guess it. There's actually a published decision where a border guard asked a suspected drug smuggler for their password, and the smuggler said no, and the border guard guessed that their password was their birthday, and the border guard was right. So it's got to be long, unguessable, and easily memorable, and the way you do that is with diceware. You've got to have strong encryption, and it's not just a screen lock, it's full disk encryption, meaning every single digit on your computer has been converted into unreadable gobbledygook until the strong password unlocks it. You've got to have everything backed up into the cloud so that when you arrive at the border, if they take your device from you, you have your data when you get home because it's in the cloud waiting for you. You should power your device down. There are some ways of hacking into a computer which are harder to do if it is cold and off, and easier to do if your device is still on. There are all kinds of biometric locks now, whether it's a fingerprint or the facial recognition. Those are good, but a password is better because they can simulate passwords. There's actually technology that can take a recording in a database of a thumbprint and convert it into a thumbprint that can be put on your device. There also are warrants being issued where cops can take people's thumbs and put them to their device. There is a body of emerging case law about the Fifth Amendment right to not hand over your password, which strangely has been stronger about a number in your mind and weaker about a thumbprint on your body. So the password is stronger than the biometrics. If you use biometrics, use it as a supplement and not a substitute for the password. You should disconnect from your apps in your browsing. As we've heard, they are putting it in airplane mode, your device, if they're searching it, and not going into the cloud. But depending on the device and how recently that you've used it, a lot of your content from those apps to the cloud is resident inside the device. So if I go to Facebook while I'm waiting in line at customs and look at my Facebook friends and send messages to my Facebook friends, and then put it in airplane mode and hand it over to a border officer, the last several things, and maybe a lot more that I've done on Facebook, is inside the device. So close out your apps. Overall, I would say that there is a scenario where a U.S. lawyer can feel pretty confident about not unlocking their phone when a border agent says, you know, unlock your phone for me. If you're a U.S. citizen, they're still going to let you in. If you've got strong encryption, you've got strong passwords, your device is off, and they take it from you, they're probably not going to be able to hack into it. Now, there are services that the government has with companies who have the exploits into these devices, but they're very expensive. And unless you are, you know, credibly thought to be a terrorist, they're not going to spend the money in most cases to purchase those exploits from the security companies. If you have put everything in the cloud before you got there, and if your employer is going to issue you a new laptop and a new phone when you get to work the next day, it probably isn't going to hurt you to have your device taken from you. So if all of these things are true, and you're a lawyer who wants to do what they can to protect their client, you know, just stand tall, refuse to unlock your device. They take them from you, you get to work the next day, you've got a new device, and they download the information, and the government probably won't be able to crack it.
So if I understood any of that, I mean, it's fantastic. So Bruce, so I don't ethically have to if the agent asks me for the password and I do everything I can to talk him out of it, if I give the password and decrypt the device, am I creating an ethical violation at that point?
So, you know, we didn't, the committee at least didn't address that issue.
Well, as an
And
ethics
the
professor.
And the ultimate question is whether it's reasonable, and reasonableness is based on this, you know, all these factors. So if you have really sensitive stuff and you don't want the border folks to see it, why would you comply, right? If you're going to cross the border anyway without your device.
And if I had followed Adam's advice, it wouldn't be a problem anyway.
I mean, it sounds unreasonable to willingly let them review stuff if you have the option of not.
So let's switch topics. Jim, why don't you tell us a little bit or a lot about what happened that day when it was when y'all's office in Munich was searched. Give us a sense of what was Jones Day's role at that time as it related to Volkswagen Group. What kind of information was seized, whether there was any warning, you know, in advance. Was there, you know, when it happened, was there a tank team? I imagine y'all were somewhat shocked. And what
Just
issues?
a bit, just a bit.
Just a bit?
The wee.
You didn't anticipate it?
Nah. I mean,
So
just
tell
the
us
wee.
what happened, when it happened,
So-
and what the status
Yeah,
is.
so I mean, to put some context around it, you need to understand, and you certainly know, Sandy, what our role was in the matter. The firm was retained by the supervisory board of Volkswagen to investigate these diesel issues. And in Germany, they have a two-tier board structure. You have a supervisory board, then a management board. And the supervisory board is sort of the equivalent of your outside directors here. And the management board's all employees. So we were retained to conduct what they trumpeted as an independent investigation and advise the supervisory board regarding these diesel issues, which I don't know that, I mean, a third of the room is working on the case and has an executive or an agent or an engineer in the case, and you're welcome for that. But what it involves is alleged cheating with respect to sales of 2 and 3 liter diesel engines into the United States that had software that would recognize when the car was being driven in a way that said it was on a test stand. And when it was being driven on a test stand, it triggered some more fulsome emissions controls that weren't in place when the car was being driven on the street. It was dense, and we learned a lot of new things, and we learned a lot of technical things, and we interviewed 700 people. It was a meaty, chunky thing, but it boiled down to alleged cheating to fool your regulators to pass a test, all right? So we're investigating this, and we're reporting to our client, the supervisory board. We are not advocates for the company. There are other firms that were representing the company with respect to the various civil and criminal exposures in the matter. So it felt very much structurally like we were doing an investigation for an audit committee for a company that we otherwise hadn't worked for. So we would check that box of independence. So it was very familiar structurally to a lot of the work that we all do here. Real sort of just, you know, belt-high fastball, garden
You gave
variety.
upjohn type warnings? stuff like
Everything. And we did it exactly like we would do it here. And it was a wonderful engagement. We had just a really great team of folks. Pete Romatowski was sort of our lead guy on the whole thing, just a spectacular guy to work with, and wonderful associates here worked on it. And everything was great. And it was one of these cases that it was kind of easy. It rolled off the tongue easy to talk about working on it until they rated us. And it's
everything started in September of 2015.
Yeah.
Y'all were engaged to start
Right
sometime
away.
that fall?
Yeah,
Right
yeah. There were some. The EPA had some conversations with the client. That they had. Had been some admissions regarding Volkswagen. Audi hadn't admitted anything, and this is an important background because it talks about where we got rated. Audi has Volkswagen has the 2-liter engines. Audi has the 3-liter engines.
And that Audi's part of the group, though.
Yeah, Audi is essentially owned by Volkswagen. I'm sorry if that wasn't clear. And the 2-liter engines were in more of the cars. The 3-liter engines, and the cars are both Audis and Volkswagens, and the 3-liter engines were in the bigger cars. Fewer cars, but way more expensive. So the 2 liters were in the cars you had when you worked for the government. The 3 liters are in your car now, Sandy. So the bigger,
Your
nicer.
car.
No, your car. And the Audi piece, the factories were within the territorial jurisdiction of the Munich prosecutor. The Volkswagen piece was in the territorial jurisdiction of a different prosecutor. There was no raid in the Volkswagen piece. There was a raid in the Audi piece simultaneous with the raid on our client on March 15th, 2017. And it was a raid. It wasn't we want to come talk to you and we want you to send your lawyers down and we'll talk about some things we want and maybe see a judge about whether this is or isn't privileged. No, it was people coming first thing in the morning with a regular good old-fashioned court-authorized trespass into our premises to come in and take all of our stuff from the lawyers that were working on the files in the Munich.
And were you in the U.S. at that point? Or
I was in the U.S., yeah. I was in the U.S. But I heard it right away. I was sort of, I kind of ran the Audi piece of it, so I knew about this. And to be complete, I had zero thought that this might happen in advance, and I didn't have any belief that it would be any more likely there than here. As we came to learn, this isn't uncommon in Germany. There are other law firms that have also been raided. They call them dawn raids, and they just execute them. And there are some fundamental differences between that country's and prosecutors in that country's views about the privilege and in investigations like these and the way we view it that lead to those things happening.
You didn't realize that at the time? You weren't aware? Had you been aware of other law firms being searched?
No. Personally, no, but our team certainly was because we had lawyers in,
You had
Frankfurt,
German lawyers.
Yeah. So they were aware that it was not an entirely, and good big law firms. I won't name them because it's not a nice thing to do, but they got raided as well. There was no taint team. There was no warning. We did, though, obtain an injunction that stops the prosecutors from looking at the materials until we resolve the issues in the Constitutional Court, and we have filed very, full-throated challenges to that. And it hasn't been resolved. So they haven't, if they've abided by the rulings, they haven't looked at the materials.
What did they take?
They took, and I can tell you this, and I have to be super, super careful because the proceedings are all under seal, but there is a ruling on the preliminary injunction that's not under seal. And I have a sense that there's a penalty for violating a sealing order in a German court.
Well, what kind of information did y'all keep in Germany? Give us a sense.
I also have a strong sense I don't want to know what those penalties are. I don't want to find out. So
you can stay here. You don't have to go back over it.
So they took 185 binders of the real good stuff, and then they took electronic data from the lawyers that were there working with us in the United States, people that we'd been side by side with doing the interviews. I can tell you this: there's no element in this whole story that relates to or even close to the crime fraud exception, which was the initial sort of, oh my gosh, I'm terrified moment that when we got raided, that there's going to be some allegation made somewhere that this representation was tainted by the client's desire to hire us to further perpetrate a crime or fraud, which would vitiate the privilege. and God forbid, some allegation that we were complicit in that, which doesn't necessarily have to be there for the crime fraud exception to apply. But I was terrified that that would be some allegation. But then when everything was translated, I'm not going to say what was in, but I'll say there's no element of that at all. Nothing at all. There's no suggestion that, that what we had was work we were doing that was somehow tainted by our client's intent to continually obfuscate and lie and cheat. Instead, it was almost sort of a backhanded compliment in some ways. It basically is, Jones Day has the good stuff. They've done a really good job in investigating the matter. They have a very good command of the facts, a very thorough command of the facts that we, the Munich prosecutor, we want them. We need them, and we want them, and we think, based on our interpretation of the law, we're allowed to have those
So
things.
what is the issue, basically? How does it come up? I mean, obviously, your position is it's privileged, attorney-client, attorney-work product, whatever, right? I mean,
Right.
that's your position.
Yeah.
And their position is it's not privileged, why?
Yeah, and so I'll say this again. I'm not talking about what they've pled because I really don't want to.
Right.
But there are things that we kind of came to understand and observe, concepts and thoughts that exist in the minds of prosecutors in Germany that are different from concepts that would be in the minds of the prosecutors here. I mean, we never would have been raided by we were dealing with the fraud section and the U.S. Attorney's Office, and of course we never thought we'd get raided in the United States. So there are four things that we think you can identify and say this is a little different, and it feeds into this idea there you could do what these folks did. Number one, there's no corporate criminal liability. So the only people that get prosecuted in the country are individuals. And so if you're doing work for a corporation in connection with a criminal investigation, there's some sense, perhaps, among some prosecutors that you're doing something other than representing an accused, and your conversations are something other than a privileged communication with an accused in a criminal proceeding.
And does it matter if you're representing the accused, a corporation that is accused in a country that does have, criminal liability like the United States?
Yeah,
Y'all were involved in the United States, so can you make that argument?
Yeah, I haven't, canvassed other countries, but I do know in Germany this is something that I think fed into the thinking that they can do these things. If they were targeting us for criminal prosecution, their law change, I think that there would have been a different thought about whether this was an appropriate thing. The second difference is this: it's not common, and how it sounds like I'm acting worldly about it, but it's not common in Germany to have a quote-unquote independent investigation where a law firm that checks that independence box, you haven't worked for this company before, you're independent, you can come in and do this investigation, and you'll report to a committee of the board or the audit committee or something like that. It's not common there. We all understand when you do that here, you still have a privileged relationship with the people that you are doing this work for, and the independence relates to your prior relationship issue. It doesn't relate to the idea that you're some third party. So if in Germany, sort of the trumpeting of we're having an independent investigation done by the supervisory board appears to be able to signal to some prosecutors that's something other than a privileged attorney-client relationship. It's a third-party relationship. And that could feed into the thinking that this stuff is not protected. And then the third thing relates to the first thing is that the privilege in a criminal proceeding is typically viewed as the communication between the accused and his or her lawyer. That's it, and we weren't representing an accused. Then the last thing that sort of fed into it, Sandy, is that there's a sense that if what you're doing is factual investigation, you're doing something other than having a privileged communication with your client. You're basically, if we were private detectives that were gone out to ask and gather all these facts, interview these 700 people, figure this all out, no way that would be protected. So you kind of smashed all those thoughts together, and that's how you get to a place where you're going to work in a country where they'll do dawn raids at law firms that are representing companies in criminal investigations where individuals are likely the targets.
So what have you done, or what has the firm done, going forward, not so much for the Volkswagen case, but for every other, international case
Yeah,
that y'all are involved in?
all the wonderful DOJ speakers give this caveat: they can't speak for DOJ, it's just their own views. I definitely can't speak for Jones Day. I mean,
Well, what would you
I get-
suggest to this
yeah.
audience here
Yeah.
as to what to do to?
Yeah.
to
So just a couple of things that you know, that I think, and I ultimately believe will prevail. And I believe I believe that on these issues, and I think that there's some educating that's going on, and I think the preliminary injunction against them using the documents is a good sign, and it's still there. I think, you know, simple, good blocking and tackling of very clear engagement letters that talk about exactly what you're doing and why the facts you're gathering are for the purposes of providing legal advice about various legal exposures, really making that very clear. And then, in your communications with the authorities, because this is a matter in which the directive of our client was for real-time cooperation, answer questions, you know, that people would ask you. In those communications, I think you could just make it very, very clear that as you're having those communications, you know, we're talking to you about the work we're doing that's protected by the privilege, because we're finding facts that are helping this company understand its legal exposures. Be very intentional and thoughtful about data storage. I'm not technical about that, but you all are way more savvy about that, about what servers things are on. You think about those kind of things. And then the last thing, it's something you tell your clients. You know, we all can tend to be sort of, I don't know, folksy or salty or whatever when we're emailing each other about the work we're doing, right? If you're doing that work in a country or a place where they may have a different view about the privilege and that stuff may see the light of day, you just think about whether or not we want to have more done by conference calls rather than writing emails back and forth about how we thought this witness was a worthless piece of whatever. You know, you just be very, very careful and intentional about the emails. I mean, it was well, hypothetically, it's a nerve-wracking thing to have to go back through all your emails knowing the prosecutors have those things and say, if you know yourself to be a little loosey-goosey in the way you speak and you're dealing
I'm
with
sure Romatowski never
Oh my God.
said anything
I mean,
sarcastic.
the first thing he did is said, search Romatowski's name, because who knows what's going to be on his stuff. But you look through all that stuff and you get a little nervous about how so you have to be very, very careful about that.
So David, there is a decision which is very similar. I mean, you've heard this description of what the sort of the issue is, hypothetically, I guess, in Germany. But there was something similar where for a company called ENRC, you had one of your SFO investigations, and a request was made. And that company had engaged a law firm like Jones Day Deckard to conduct what appears to be, from the decisions I've read, an internal investigation. And your office requested, I guess subpoenaed, I don't know what the technical term is, but made a demand for various documents, including the notes taken by the lawyers of the interviews of the ENRC employees in this internal investigation. And the High Court, which for this audience that doesn't practice, the High Court is not the Supreme Court, right? It's not. No. It's a one judge. It's above the trial court, but below the appellate court.
High Court, Court of Appeal, Supreme Court.
Okay, so a judge in the High Court ruled that there was no litigation privilege as it related to these notes and some other things. But as to these notes, as I understand it, based on two bases, that number one, because litigation was not reasonably in prospect as opposed to there being an investigation, and the dominant purpose of the internal investigation was not for the defense of litigation, but was for sort of like what Jim was describing, fact-finding, something like that.
Yeah.
So, and I know that's on appeal, and I know you feel a little uncomfortable about that, but the concept about internal investigations being done by major law firms and companies, and the work product not being protected or being vulnerable to subpoena
or production to the government. Can you describe that? Because it's a concept that we don't really understand here in the United States.
We have usually been of the view that first accounts of witnesses are, we want to see them. We do not accept necessarily that they are privileged. We want to see them for two reasons, well, for three reasons. One, because they are the facts. Secondly, because seeing them enables us to assess the credibility or potential credibility of potential witnesses. And thirdly, it would be necessary for us to see them in order to fully discharge our duties of disclosure in a criminal prosecution.
So,
I mean, that's our view. But can I just, going back
Yes.
to the case, can I just make one or 2 points
Please.
Which are quite important? Firstly, in legal London, there was about a year ago a buzz that somehow the SFO was attacking privilege. That is complete nonsense. What we have always said is that obviously we recognise privilege as a legal right and a human right, of course we do. But where we do not necessarily accept an assertion of privilege, we will ask for justification and we will, if necessary, challenge it. And we have done so twice. Once against a bank where in fact we were ready to go into court and the bank backed down and gave us the stuff we wanted to see. And on the second occasion in ENRC. Those are the only two occasions when we have challenged it. The appeal, by the way, in ENRC is scheduled for the 3rd of July of this year to be heard in the Court of Appeal. The ruling is very definitely fact-specific to the particular facts of the case. The judge makes very clear at paragraph 50, if anyone wants to look it up, of her judgment.
And the material, in the materials, the opinion is there.
Yeah. And she makes very clear at paragraph 50 that really there has been a complete failure on the part of ENRC to produce any evidence that this material was in fact privileged. The crucial point, and one which almost every commentator gets wrong, is this, that at the time Deckerts were engaged to carry out their investigation by ENRC, the SFO had not decided to open a criminal investigation. And the judge therefore held that Deckerts were engaged to do a genuine fact-finding exercise. That's the key to the case.
And Jim, you've looked at this, and,
Yeah.
and how does this sort of parallel or relate to what what you've dealt with in the search issue?
Yeah, the parallels are that in both matters there was voluntary engagement by the clients or the companies with the authorities, right? The lawyers have been tasked by their clients to share information, right? That's the big parallel that I see. I mean, the big difference, and it's one that law firm had its day in court before you had the stuff. You went to a judge and talked about whether this stuff is privileged or not. You didn't go in and raid them. But that's the parallel, Sandy. In both matters, the clients were saying to the lawyers, go share this information with authorities who we may have to deal with at some point, at some time, at some level. I'm not as familiar with the Decker case. And you compare and contrast that with representing a corporation where they've said, we've looked at this and we have nothing to say. We're not, and the prosecutors would say, you're not really cooperating other than giving us documents. We're not voluntarily cooperating. You say, we think you're wrong. We're going to defend the company. We're going to defend the company. And what strikes me, just personally me, as odd is it's the former setting in which you're more likely, if these two matters are sort of case studies, to have somebody come in and aggressively attack the privilege where you've started out cooperating. I can't envision somebody just going and raiding the law office of the defense counsel who's not cooperating. I'll just say, no, just bring it on. We'll show up in court. We plead not guilty. And I don't think that that's a setting in which anybody would even dream of going to raid that law firm.
Right.
So there's, which strikes me as incredibly odd,
yeah.
you know. Yeah.
In ENRC, it seems like one of the issues is whether or not, an investigation, and I know you said there wasn't an investigation, but it seems to me that the argument is it was certainly anticipated and that what they were investigating is a concern that there was a bribery, I think it's a bribery in Africa or something, issue, and there was a major concern on the part of ENRC and its counsel that in fact, there may well be a problem. But the distinction is that the judge said, well, an investigation doesn't cut it. It's got to be something adversarial.
Yeah,
So
that's part of it. Yeah.
so, so is that's the problem, Jim?
Yeah.
I mean, an investigation, from my perspective, is always adversarial anyway. But,
And forget, you're always doing that for the purpose of giving legal advice. I mean, we're not finding these facts out just because we're voyeurs and want to know what happened. We're lawyers. We're trying to find out facts so we can give legal advice about exposures. Whether that exposure is somebody that we're going to beat the hell out of and fight with or somebody we're going to cooperate with is a different thing. But you're gathering facts for the purpose of assessing a legal exposure. So I think that adversarial, non-adversarial thing, if the authorities are relying on that to vitiate or kick it, I think that's just wrong. I think it's wrong. You're gathering facts so you can tell your client, give them educated, informed assessments of legal exposures. That's why we all do this. There isn't some other reason we're doing it.
so David, what was the reaction in the bar in London when this took place?
The reaction was that I think.
What was the reaction in the pub?
The reaction amongst the bar was, generally speaking, hell, what we're going to do, all these investigations are going to be done in the US by US law firms. That was what the reaction was.
Oh, we're going to lose business.
Exactly.
But beyond that, was there a concern that,
There
that
were
the
pe- pe-
SFO had
people-
gone after what most lawyers consider a privileged
There
property?
was this stuff about, the SFO were attacking privilege, and that's why I've said since the judgment came out that everyone should just calm down, because this is very, very much fact specific.
Sandy, I could see it impacting at some level people's assessment and maybe this about like real-time cooperation, which is a big thing for the DOJ, and they want it to make sense, because I believe both these matters were settings in which there was ongoing sharing of information by the law firms with the authorities, and then at some point in time the authorities got a sense, and you would know better than me, sir, but got the sense that it wasn't going well enough. It wasn't going well enough, so in our case they came to raid us, and in their case they cut a subpoena for it. And some folks may, in certain settings, say, well, I'm going to rethink that a little bit. I'm going to wait till I really know every single thing. I don't want to leave to possibility that a prosecutor is going to think that they're not being told everything in real time. I mean, I could see people sort of reevaluating that factor a little bit in certain circumstances.
So, Bruce, does this raise any ethical issues for
Well, yeah.
those of us that are doing cases internationally? I mean, Germany does something that is contrary, that really wasn't anticipated. Probably, in the UK, I doubt that was anticipated either.
Yeah. So if you're thinking ethics from the disciplinary risk, I mean, obviously, no one's going after Deckert and Jones Day, for a disciplinary case, because there's enough lawyers out there stealing clients' money and committing felonies, and the disciplinary authorities don't have the time or the inclination to go after people for unreasonably, failing to reasonably protect confidences. But the question is, going forward, Deckert may not have anticipated being subpoenaed or losing a subpoena battle, and Jones Day may not have anticipated being searched. But now there's, hundreds of people who are here and reading this stuff and watching this stuff and aware of it. And the question is, does the standard of care for lawyers doing transnational internal investigations shift? Jim gave us what may have been advice about good practice, but does it become the standard of care? And so the next time, there have been other searches in Europe, by the way, of like lawyers' offices and stuff. So it's not completely unanticipated, but now it's more anticipated. So the next time somebody does the equivalent and doesn't document as well as you can, or store things in the US rather than in Germany, the UK, et cetera, or pay to bring all the witnesses to the US to be interviewed in New York or DC, or, you know, not write things down, but rely on your photographic memory, or whatever it is that you think is good practice, does that become the standard of care? Now, it doesn't become significant until the Deckerts and Jones days of the world get sued in a civil case, probably. But, you know, the day may come. And so I think from, you know, whether you view it ethics, probably not in the disciplinary sense, but in a broader sense of what's good practice for lawyers, I think it raises important issues.
And Bruce, there's an overlay if it, about the exact setting in a case where they've already shown they think things aren't privileged. The idea of changing your practices for the rest of that case, in theory, a prosecutor who's overreached already could view that as obstructive, right? I mean, right? I mean, so you're saying, you know, your ordinary practice was to store your documents in Dusseldorf. Your ordinary practice was to have your electronic information stored in a way that was accessible. We've now raided your office, and we said, well, that's it. The rest of this stuff is going here, there, everywhere. You know,
Well,
and the investigation's still going on.
So not to plug my services, but I'll give you a letter that'll give you an advice of counsel defense if you're changing your practices.
Can you translate it into German? How will it translate?
That I can't do. But I mean, what I was really talking about is the next time you get hired to do an investigation. But I think you can change your practices in light of changes in the law or what appear to be changes in prosecutor practices abroad, or, you know, whatever. I don't think that's obstruction. I think it's.
I agree with you. I'm worried that the person that's going to be making that, weighing that, is the person that's already seen or believed it's okay to raid our office. Right? I mean, it's not going to be a reasoned assessment by someone like you. That's a potential concern.
So David, starting on April 21st or whenever you, and wherever you go back into practice, because you've been a defense lawyer before, correct?
I was a barrister, you know,
barrister,
a hired
sorry.
advocate, prosecuting and defending for 25, 26
Right.
years.
So presumably you're going to go back to do what a lot of us do here at some point.
My stock answer is that I'm going to hawk myself around the bazaars of legal London and see if I can muster a flicker of interest.
So I'm hoping that you know, you're very successful in that. But so once you hawk yourself, what do you expect? What would you be saying if you were a defense, you know, in April 21st on, you know, a barrister that was representing one of these companies, and, you know, a prosecutor asked for, and you're conducting an internal investigation, and a prosecutor asked for your stuff.
Yeah.
What are you going to do? I mean, you're an aggressive guy.
I know exactly what's coming. And
so what are you going to say?
I think you probably know what my answer is, but I'm not going to give it because this appeal is coming up.
You're an advocate, in other words, right? I mean, you're going to advocate for your client.
Yeah.
Okay, good. There, Jim, I circulated to you, to everybody here, another high court opinion, which just came out. It's in the Bilta versus Royal Bank of Scotland case. And it's a little different situation, except that it's basically the same. It was a request by, or a subpoena by liquidators of a company, information from an internal investigation for RBS, or Royal Bank of Scotland, who had hired counsel based on basically a tax investigation. And I guess for the agency that you used to work for, right? Were you? Yeah. Her Majesty's Revenue and Customs. And the judge in that case came to a completely different outcome than in the ENRC case that's pending. Even though there had been some exchange of information, but had concluded that the company, you know, had a reasonable concern about an investigation by the tax authority. Mm-hmm. Could you square the two cases?
No, I can't. I mean, I think one's correct and one's incorrect. I mean, I don't square those. There's some history that was going on in the Deckert case that where different law firms then got involved, and there were some issues where maybe the authorities in that case felt more righteous in saying they were being sort of jerked around, quote unquote jerked around. I mean, I don't know if that, because one law firm was replaced by another law firm. At one point in time, the opinion says the company's position was it was cooperating. Then its position was it wasn't cooperating. So there's a muddier, murkier fact record there, Sandy, that maybe underlies that court getting an opinion that I would respectfully disagree with. And I think the other one just got it right. And the other one doesn't seem to have that kind of muddiness to it.
So I want to ask a couple more questions, but then I want to open it up for some questions, and you can get some free ethics advice or whatever. I mean, you got the professor here. So I want to talk a little bit about this lawsuit. So what are you seeking in the lawsuit in Boston? What exactly you're seeking? What's the status of that lawsuit? And I really want you to describe, to the extent you can, some more of the clients and what the circumstances were, some of which were searched more than once. But
Sure. The case Al-Assad, we filed it in September. The government moved to dismiss in December on grounds of standing and on the merits of what the Fourth and First Amendments provide.
And who did you sue exactly?
We sued the Secretary of DHS and the subsecretaries or commissioners.
So not the acting general counsel, you didn't sue him,
No,
right?
we might see him in court, but not
Good.
And we seek only injunctive and declaratory relief. We want a ruling that the First and Fourth Amendments require a warrant to search a device, and that the Fourth Amendment requires probable cause to confiscate a device. We view the new policy the CBP has put out as being a small step towards what we want, in that sometimes it requires reasonable suspicion to search, but we think that it does not nearly go far enough towards what we want. There's going to be an oral argument on the motion to dismiss in April. In terms of things that have happened to our clients, just for example, we represent a journalist who works in Haiti, and when he came back to the United States...
He's an American citizen, right?
This is the one, we have 10 clients who are U.S. citizens. This one is a lawful permanent resident.
Okay.
Of Haitian ancestry. So he covers, the continuing violence and disorder in Haiti for, lots of traditional media. And when he sought reentry to the country, not once but twice over a month-long period, he was ordered to unlock his devices and objected that he was a journalist. And then agents proceeded to go through his communications, including communications that he had with news sources. And this was destructive to his practice of media. And while we're glad to see that the new policy has taint teams and such for the benefit of lawyers, there of course are many other professionals, such as journalists, who this is an issue for. I think if one wants to get a flavor of what this is like for ordinary people and how they experience the intrusion, I think the Knight Center has done some really interesting FOIAs that we should hear about as well.
Carrie?
Yes, so we did submit a FOIA request to DHS and CBP and ICE for information about the execution of this border search policy, and filed a lawsuit based on that FOIA request last March, almost a year ago. And in connection with that FOIA request, we have received some documents. We're hoping for many more in the future. But among those documents, we received a kind of a trove of complaints from travelers who wrote into the DHS TRIP program, the Traveler Redress Inquiry Program, which is kind of, as I understand it, a catch-all for traveler concerns, particularly those who might fear that they've been placed on a watch list inappropriately, or just want to express other concerns with the way they've been treated at the border. And I think roughly 240 of these complaints detailed searches of travelers' electronic devices. And the complaints themselves are pretty harrowing, actually. Many of them describe border agents going through family photos. Some people raised religious objections to a male officer reviewing a female's photos, Muslim women who, it's against their religion for men to view them without the hijab. Many other travelers just objected to border agents reading their text messages, their emails, other correspondence, looking through newspapers that they had brought back from their travels. One was a journalist, a bureau chief with the East Africa Bureau of the New York Times at one point. And these are the kinds of complaints that we find particularly concerning. It seems as though he may have been selected for search because he was a reporter. And he was asked about confidential sources that he had spoken with, interviews he had conducted, notes that he had taken for his digital camera that he had brought on his trips. And we've seen other reports, public reports by reporters expressing concerns about similar searches of their devices at the border. And so I think the complaints that we've seen speak to just a broader concern with the breadth of the policy when there's no requirement for any basis of suspicion when these searches are conducted. The searches can therefore be conducted on discriminatory grounds, on grounds targeting people because of their work as reporters or attorneys or other bases along those lines. They can also be conducted randomly, which we would think would be better than these discriminatory bases, but the arbitrary or random nature of the searches sometimes masks those problematic practices under the surface. And it may be the case that many of the searches are conducted based on what would amount to reasonable suspicion or even probable cause, but the way that the policy is structured, we can't be sure that that's the case.
So Joe, what do you do when you get a complaint like that? Do you does your office investigate that?
No, so our Office of General Counsel doesn't investigate that. So it may be reviewed by Office of Professional Responsibility through the redress program, or people can always contact our Inspector General, and they can do an independent review, and that happens. So there are multiple different kind of avenues that people can go to if they think they've been kind of wrongly treated.
By the way, tell the audience here, how many lawyers are in the General Counsel's office?
We have roughly 2,000 lawyers in our General Counsel's office. So about half of those lawyers do immigration cases in immigration court. Yep. Our department's about 230 or 240,000 people in the department.
So other than the Department of Defense, it's the biggest department that we have?
I think VA may have, I'm not sure what the numbers are for VA. It is second or third biggest.
So we're getting toward the end. My watch stops. I have to look at my cell phone. So we have 15 minutes. So does anybody have any questions? And by the way, do we have a microphone in here, Ray? I can't see anything because there are lights. But I can see anybody. If anybody has a question, just stand up and yell. May I have a question? Yes. Okay, that's a very good question. So the question is, what is the border? So Joe, what is the border?
So it's basically, obviously, the geographical border of the United States, but also there's a term called functional equivalent on the border. So if you're coming from another country and you fly into an international airport in Denver, that's considered a functional equivalent on the border, so the same rules apply at a port of entry like that.
Don't you also interpret the functional equivalent of the border to include within a certain number of miles of the border? Aren't non-citizens sometimes, or people suspected of being here illegally, stopped in cars within a certain number of miles of the border? And if so, in theory at least, could customs agents pull people over and search their cell phones?
Well, so there's an extended border kind of doctrine where as you get away from the border, if there's a reasonable belief that the person just came through across the border and there's reasonable suspicion for some type of criminal activity, then there are certain authorities. But as you go away from the border, that gets weaker. So there has to be some sense that the person has recently come across the border as to where you do that. So it's not like we have our officials that can kind of roam in the interior and just because they're an official of our department start taking people's cell phones and searches.
So you have ICE agents and you have Customs Border Patrol agents. What's the difference?
So the ICE agents really are more investigative, so they investigate crimes, cross-border crimes, things like that, whereas the agents within the Customs and Border Protection are the guys at the border who are engaged in protective and enforcement activities.
Are ICE agents at the border as well? I mean,
They can be, although they're not the typical officials you would encounter if you're just, in the ordinary course coming across the border.
so when these, oh, go ahead. Do you have a question?
Very short. There are fixed checkpoints, sometimes as far as 100 miles from the border, which are looking for typically people who might be undocumented immigrants who got through. And it's lawful, going back to the 70s, to stop everyone absent reasonable suspicion for the screening. In that scenario, I would assume that a stopped car, the CBP would not have the power to search a phone absent a warrant because it's the interior of the country.
Right. I mean, it's obviously highly kind of fact and case specific. So, but generally in the interior of the country, they're not searching phones. Right.
I think there has been a case, if I'm not mistaken, distinguishing between the kind of internal U.S. international airports, which are the functional equivalent of the border, and the extended border concept that you described and that we're talking about now, and suggesting that the search authority, the border search authority, would not be the same in the extended border context as it would be in the functional equivalent of the border
I
context.
think that's right, yeah.
And do you have agents abroad? I mean, can there be these searches abroad?
There are some countries where we have agreements. Obviously, we're on a sovereign territory of another country, and so there are international agreements where we do have some called pre-clearance arrangements. We do have people overseas.
So there can be digital searches there as well?
That I'm not familiar with as to whether they do any digital searches there. I'd have to add. I haven't asked that specific question.
I'd
but-
say anecdotally, I have a friend who was searched. I believe he was traveling through the United Arab Emirates, and his phone was searched for approximately 3 hours.
By an American?
Yes.
Oh, okay. Anyone else have a question? I can't really see anything, so you got to speak up if you do. All right. Well, I think that I think that's it. I mean, we're ending a little bit early, but we've had 3 long days, and I appreciate the people that stayed to listen to this. I thought it was really interesting, and I got to figure out what the heck I'm going to do going forward. So thank you very much.